Court calls the case People versus Chanel Griffin. Miss Pate is here, and I think your client is in Zoom.
Assistant Public Defender, on behalf of Ms. Griffin. Oh, can you please state your name for the record, ma'am?
I'm here.
State your name.
Chanel Griffin.
Thank you, Your Honor. Me and Ms. Griffin had the opportunity to review the PSI. We only have one update. I believe since the report has been written, Ms. Griffin states to me she has taken care of her outstanding warrants. Outside of that, we have no corrections to the report, and we would respectfully request the court adopt the probation's recommendation for the sentence.
All right. Ms. Griffin, anything you want to tell the court before I impose sentence? Question mark.
Ms. Griffin, was there anything you wanted to say before the judge imposed sentence?
Oh, I'm sorry. No, sir. I didn't. Oh, maybe
Right.
you guys can't hear me. I'm sorry.
Sentence of the court, $480 fines and costs, 93 days in jail, suspended. When can you pay the fines and costs, ma'am?
I can have it paid off in, I say, like 90 days.
Did she say 90?
I believe so,
90.
Your Honor.
90?
Yeah.
Like
90
90?
days. 90, yeah.
Well, you're gonna have to do it a little bit sooner than that. I'll give you to February 28th, 2026.
Okay.
All right, thank you.
Thank you so much.
Thank you, Your Honor. Thank you, Ms. Griffin.
Thank you.
Court calls the case People versus Ethan Ryans.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ryans, who appears on Zoom. Clerk, please state your full name for the court.
Good morning, Ethan Ryans.
Go ahead.
Thank you, Your Honor. Today's date and time set for sentencing. We have had the opportunity to review both the assessment as well as the recommendation from probation, which I have had the opportunity to review with Mr. Ryans. He does just have one request as to the sentencing recommendation. We're asking if the court would consider not imposing the twice weekly, or in the alternate, consider possibly only once weekly of the AA classes. Mr. Ryans does state to me that he continues his enrollment in school. It's my understanding that he's taking 16 credit hours as well as working during this time to earn money. He does have some concerns about both keeping up his schooling with his job if he is attending 2 of those per week. To my understanding, he has been completely compliant on his bond, and this is the first offense of something of this nature. Outside of that request, Your Honor, we would ask the court to adopt probation's recommendation.
Sir, is there anything you want to tell me before I impose sentence?
No, sir. Pretty much as my attorney has stated, I've tried my best to stay compliant with my tether. I have quit alcohol earlier this year in April, and I plan on keeping that track. So,
Where are you in school?
Washtenaw Community.
What are you going to be when you grow up?
Currently, I'm studying business administration and looking to transfer over to Michigan State with fall 2027
To where?
enrollment.
To where?
Michigan State. That's where I'm looking to transfer to for management.
Why? For God's sakes, why?
A lot of people feel like I'm betraying you, Mish, but honestly, I feel like the competitiveness.
You miss that might get worse. Why are you going to transfer into state?
I feel like the environment is just a little bit better for me. The competitiveness with
Have
U
you
of
ever
M.
been there?
No, I took a tour there back when I was
It's like
17.
you took a tour at 17, and
Yes,
it took
sir.
forever, didn't it? None of the buildings are together. The whole place is like spread out.
Yeah, the entire city is the campus.
Yeah. So you really want to be a Spartan?
Yes, sir.
Well, we might have to change this sentence. All right, young man. Well, I wish you all of the best, and I'm just teasing with you. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient treatment, attendance at at AA meetings and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court that you are placed on 18 months probation. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can you pay that?
Give me about 48 hours, please.
48 hours?
Yes, sir.
Oh, I like you. All right. I'll tell you what, pay it by the 26th, okay?
Yes, sir.
Has the Spartan never told me yes, sir? No, yeah, he's gonna be the first.
I have.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an intensive outpatient substance abuse program, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of victims' impact panel attendance to probation. You continue the scram tether an additional 30 days in lieu of 5 days in jail. All order 93 days in jail that is suspended. Thank you.
Thank you.
Thank you, Your Honor.
And sincerely, young man, good luck to you.
I appreciate you. Thank you.
Good morning once again, everybody. Happy Monday. Welcome to the Courtroom Files Live. Judge Simpson is in a good mood. That's always nice to see. Barbara, thank you for the $5. I very much appreciate that. Nice way to start the day. In a little bit, maybe 15 or so minutes, we're going to have a brief story time with Dan. There's something I want to share with you guys, but we'll ride with Judge Simpson a little bit first.
Opportunity to review both the assessment as well as the recommendation from probation. As to the recommendation, we are respectfully requesting that the court adopt it.
Sir, is there anything you, Ms. Blair?
Your Honor, Teresa Clare on behalf of probation, I would just like to make the court aware, I did receive Mr. Williams's victims impact panel attendance. Also, so the court is aware, Mr. Williams is already on probation with me on another matter. This case is not a violation of that case. It happens prior to being.
Got it. All right, Mr. Williams, anything you want to tell me before I impose sentence?
No, thanks.
Okay. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of substance abuse and mental health treatment. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'm going to place you on 24 months probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. I will waive the probation oversight fees. When can you get that paid, young man?
I was wondering if I can work out a payment plan with my probation officer.
Is he already on a payment plan?
Yes, Your Honor.
All right. There'll be a payment plan as directed by probation. Understand that?
Yep.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a dual diagnosis programming, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's impact panel attendance to probation, which is completed. I'll order 365 days in jail, credit 42. The balance is suspended. All right. Thank you, sir.
Thank you.
Thanks, Mr. Williams.
Barbara throws down another $5. Thank you so much. But I'm going to go ahead and do story time now real quick. Bear with me for just 2 or 3 minutes, and then we will get back to court, but I think this is important. So you guys know, if you've followed us here at TCF for any amount of time, just how important our animals are to all of us. I mean, I've got Ellie here with me right now. Good morning, sweetheart, by the way. She was a terror last night, but all of a sudden, yep, flop down, have me pet your belly. I see how you are. So anyways, our animals are important to us. So some of you already know the story, but about a week, 10 days ago, something like that, I caught on one of our Ring cameras a rabbit that was running around that looked a lot like one of our rabbits. And members know we even have emojis for Floppy and Verity, who are our two rabbits. But the good news is it wasn't one of our rabbits, but it was a rabbit that was definitely a domesticated one that somebody had cut loose. And I always hate to see that, but it happens. So I chased this rabbit around the neighborhood trying to go ahead and get it, because it won't live outside. Domestic rabbits don't have the instincts, but people get them and they cut them loose because they're not what they think that they're going to be. They think when they're getting a pet rabbit, they're getting something like a hamster, but to be truthful, you're getting more something akin to a cat or a dog for the needs that it has. So anyways, I chased this rabbit around the neighborhood trying to get it and broke a toe in the process. But I wasn't able to, and we put out a humane trap to try to catch it, to be able to give it a home. But we weren't able to catch it. But a neighbor did over the weekend, and we had been communicating via the Ring app about this rabbit, and we went ahead and she was able to get it. And she reached out to me, and what I had said all along was, if somebody can catch this, I'll go ahead and make some phone calls, try to get it at the Humane Society or a rabbit rescue and get it adopted. Humane Society has no capacity to take it right now, and the rabbit rescues around the greater Phoenix area where we're from aren't taking any rabbits right now. One that I talked with has actually, get this, had 1,600 requests to take in rabbits just this year. This is how prevalent this problem is of people getting pet rabbits and not being able to care for them. You're so sweet. It's sad. So, yeah, 1,600, Michael, it's crazy. So, we talked about it. The problem that we have here at the bunker is that our rabbit room is full up. We don't have room for it. And to be truthful, with rabbits, unless you get them together when they're babies, they tend to become very territorial, and you have to spend a whole lot of time getting them to bond with each other, or they will kill each other. They will get violent with their own, where with everybody else they'll run away. So, Grandma TCF is stepping up to the plate. She decided that she wanted to take this rabbit in and make some space for it in her wing of the TCF bunker. So we're waiting for a couple things to come in, but later today we're going to go pick up this rabbit from the neighbor who's been nice enough to keep it in a kennel that they have for the last couple of days, and it's going to be our rabbit. And let me go ahead and pull up a picture to show you what we're looking at here. That guy right there. Right now we're just calling it Bunny. I don't know if it's a boy or a girl. It's probably 1 to 2 years old is my best guess. I have seen the rabbit. I went over to the neighbor's house, spent some time with it. Very compliant bunny. I think it'll be a good pet for us. It's not going to have quite the fancy digs that the other two have, but it will be safe and it will be cared for. So I bring all this up because I'm going to do this. And you are under no obligation, but I bring it up because Barbara has already thrown down $10 today. Any super chats we get during this show today, any super thanks after on the on-demand version, and any donations made today at courtroomfiles.com, they will go and be earmarked for the immediate care of this bunny. It's going to need a vet visit. It's going to need to, have its shots, things like that. Anything left over, we will go ahead and we will send to the Humane Society here in Arizona. So you're under no obligation, but if you would like to help out, that's where today's super chats, super thanks, and donations via the website will go. It will go to the immediate help of this rabbit to get it off to a good life with us. And again, any extra that would be there, we will go ahead and forward to the Humane Society. So thank you in advance for anybody who chooses to do that. And Barbara, again, thank you for the $10 you've already done. I've talked enough. Let's go back to Judge Simpson.
All right, just try to make sure you do it within those windows. Okay. The defendant is to seek an alternative sobriety court, either 14B or 15th, which may be available. You live in Ipsy though, so maybe 14B might be a shot he could take.
Yeah, we were going to kind of explore both simultaneously. He does work in Ann Arbor, very close to the 15th District Court. So we were thinking that for review hearings, that might be even more accommodating with his schedule to ensure he can maintain employment and his obligations under the program. We were going to be speaking with both of the courts to help determine which is the most appropriate.
Okay. I'm just thinking as the new sobriety court came in that, well, anyway, I'm going to adjourn the defendant sentencing to January 28, 2026 at 12 p.m.
Thank you, Your Honor.
Okay. All right. Thank you. How are you, sir? Yes.
Thank you, Your Honor.
Court recalls the case People versus Reginald Sims.
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Sims, present standing to my right. State your name.
Reginald Sims.
Your Honor, date and time set for sentencing. We did have an opportunity to review the report. We believe it to be factually accurate. No additions, corrections, deletions. If I just may allocate on my client's behalf.
Yeah, you may.
I know that based on your tone, I think that I think you know what we need, what else we need to address.
Yeah.
If you would prefer that we address the bond violations first.
Might need to. do
Okay.
that, but
Certainly.
either way, whatever. your
Well,
pleasure.
we could start with that. That's fine. We were given the bond violation report. I did have an opportunity to review with Mr. Sims. We went one by one, Your Honor. I understand that the court might have concerns that looks as though there's some type of pattern of disregard for this timing. And what we would submit to the court is that Mr. Sims has been on this device for about 4 months now, about 120 days, testing 3 times a day. I'm no mathematician, but over 360 tests, I believe. What you see in front of you, I believe, is the extent of the late tests. I believe that there are several late tests, some of which are right outside the window, some a little bit delayed. Of course, there's no excuse, no justification for it, but to provide a little bit of context, Mr. Sims works overnights. He works at Ford. And so those tests primarily in the middle of the day would be when he's sleeping. He usually wakes up about 30 minutes before his 6 p.m. shift. And so he found himself having issues. We discussed how of course, we would have been more proactive, brought this issue up prior to getting this bond violation report so that we could find a schedule that would be more conducive with his work schedule, testing schedule, I meant. That being said, I don't think he's had a single positive test since he's been testing, whether before this, after this, at any point in time. I think he's demonstrated that he takes the court's orders extremely serious, albeit with some hiccups here, but nevertheless stands before you taking accountability for those. Is intent on demonstrating to the court, as he's already done for himself and his family, that he's going to abstain from alcohol.
When I look at this, though, I mean, it's a 3-hour window, and I'm unclear as to why he can't get himself in that window on numerous occasions. I've got 1, 2, 3, 4, 5, 6, 7, 8 missed windows. I mean, in some, he's up to an hour late in terms of testing.
5 in the morning. There's 2 tests. There's 6 to 9 and 12.
Right.
Yeah, so it's 2 months.
Yeah. So, Your Honor, he's working 6 p.m. to 5 in the morning. So basically, he gets home and it's testing windows about an hour later. So he's basically got to fight to stay awake. And then sometimes, again, it's no excuse, but he falls asleep. And so before that 6 a.m. window starts, he gets home at about 5:15, and he's basically got to fight it for 45 minutes to stay awake so that he could submit to it. Sometimes he misses that. And then the 12.
I get that, but there's only one of the tests that's a 6 a.m. test.
And then still,
12 to 3 is the next one.
and then the next one is 12 to 3. And then he's saying he sleeps during that, gets up at around 5 p.m., gets ready for work and goes to work.
So I get that. So then why is he missing his 9 p.m. test, which are 3 of these?
Your Honor, I know of one time I traveled and didn't get there to 12:07. Maybe it's something like a 12:04, 12:07. The other two, I'm going to honestly say machine. I work, and I usually do that on my break. I'm at work at that during the 9 p.m. to midnight. So I've taken it every time, in my opinion. However, I did notice once or twice that it called for a late register. It said it did not, and I assumed or thought I did. So I do the thing all the time. Is, you know, like I say, I work. I'm sleep during the 12 p.m. to 3, and I've missed out a few times because I just wake up 15, 20 minutes behind, so forth. But then now I'm taking the test, Your Honor. I don't drink.
I mean, I hate to do this, but because if I get, I mean, the cold-hearted reality is that these are really violations of tether. It may say there's no distinction between that and drinking, but certainly the court could treat it that way. Is a scram tether going to work better for him? Or the 30 days that he's going to be on something?
Your Honor, if I may say, I'm also a coach, so there have been a few times where I was either with the kids or the parents, and you know, I'm always trying to break away, and so I can't do that. So there has been a few times where I'm in the midst of school administrative stuff because I got to blow up between the 12 to 3, and I try to get, you know, and that you can see that they're just a few minutes behind. But I participate as a coach also at Belleville. I'm a coach and for 20 years, and so I am a part active as well as working. And I'm trying to make that time. There are only times.
Well, but you got to make the time.
I have been.
Otherwise, what's going to end up happening is I'm either going to have to incarcerate you, I'm going to put a scram tether on you, which in dealing with the kids, and I see that it is going to be probably more problematic in terms of what you'd have to explain to them.
Your Honor, when you look at the report, it recommends basically giving him an audition here, 30 days, get it right, or he has no excuse. I think that that's fair and appropriate. I've impressed upon Mr. Sims the importance of showing the court 30 days without a single violation. I think we would respectfully request the court adopt that, give him an opportunity to prove that he's going to be intent on getting it done.
I just say there's a 3-hour window. And you just don't have to wait to the end of that 3 hours. You just have to do it within that 3-hour window. So in that respect, you really shouldn't be missing it. Okay, you just have to find time within that 3 hours to do that. All right, am I understood?
Understand.
Go ahead, Counsel, as to sentencing.
Well, I just briefly alluded to one of the points was that 30 days on the sober link. I think, again, based on everything we just discussed, I think that's fair and appropriate. We'd ask the court to adopt that. As it relates to the impact panel, we did tender proof of completion to probation, that has been completed as well. I understand that they are recommending in the alcohol education program. I think that given what I know about Mr. Sims, that would indicate that he can complete that program and move forward with this. Otherwise, we think that the report and recommendation is fair and appropriate. Ask the court to adopt it.
All right, sir, is there anything you want to say before I impose sentence?
Yes, Your Honor. Once again, I've been a standing citizen. Not only did the court have to give me a penalty or to say I had to do the breathalyzer, I did not drink. I have not drunk since the day of my accident. I want to take responsibility of that. Due to leadership, I'm part of the, I lead kids around and coach and things like that. So I have to make an example for myself as well as others. So yeah, to tell her things like that, yeah, I'm a good citizen. So I don't want to be explaining to these kids like, you know, the breathing. Like I said, I had to run out and do those things. I couldn't do that openly, but, you know, doing positive things, staying active, and, you know, I just work, stay active with the children and spend time with my grandkids. So I follow your system. I believe I apologize for the times that I was late. However, I was just late, you know, based on activity and or sleep. But I respect the system. I apologize for being here, wasting everyone's time. And I'd like to move forward with you on good behalf.
Who's here with you?
My,
Who?
my missus.
Should say that louder.
I didn't.
You like whispered it, like
Oh, no, I didn't
you
think
didn't
so.
want anybody to know. I figured that was
No,
who it
no.
was.
She's here.
Ma'am, you want him back?
Yes, but I'm tired of talking to my.
Ah, see, I knew. That's why I wanted to talk to her, because she looked responsible. Like, you know, you're talking about what a good and upstate citizen, and I'm not disputing that, but I think somebody helped you get there.
I sleep during that time period, Your Honor. So
Well, hold up.
12
Hold
to
up,
3.
hold up. See, why are you
Yeah.
talking?
No.
She just told me that she's trying to remind you. She's sick and tired of having to remind you,
Understandable.
right?
Yes.
So, and all that really tells me is that at times, your husband is just not listening. She's trying to get you to do the right thing and follow all along. Am I right, ma'am? Yeah, okay. See, she's still trying to save you. All right. Listen to her.
I do.
She'll make sure that you'll get this done so you don't end up in trouble. You hear me?
Yes, sir.
I guess if she wants you back, I'm not going to stand in the way of that. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol. Tell them not to do that. Alcohol highway safety education program and abstinence from all intoxicants for a year. Therefore, the court will follow the recommendation of probation with stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'm going to place you on probation for a period of 12 months. In order, $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. When can you pay that?
Within 30 to 45 days, Your Honor, I'll put that.
Pardon?
30 to 45 days. Months.
You ask the person in charge when you could pay it? Or are you just making that up?
I just know I'll put that.
Ma'am,
next
ma'am, ma'am, when can he get this paid? In a month.
The next month's budget.
Well, no, you know what? You just,
The boss has
you
spoken.
need to stop talking. I just went to the brain trust. I got it.
Okay.
In a month. So by January 30th?
Yes.
Thank you, ma'am. I would imagine every time you started thinking on your own. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. You're to provide proof of the victim's impact panel attendance to probation. That has been completed. I'm going to continue the sober link for an additional 30 days in lieu of 5 days in jail. Order 93 days in jail suspended. Sir? One thing about me is I've got a very good memory. And your wife told me she's reminding you. So if I have a missed test, late test, anything like that, that means that you're not listening to her. I will use that jail time for that sole purpose.
Well, thank you, Judge Simpson, for cutting your feed right in the middle of that lovely lecture.
Ms. Atkins, good morning. Ms. Atkins, you're here because you've been accused of it's like 8 total charges. 1 count of theft, retail theft between $100 and $750. 6 counts below $100 and 1 scheme to defraud. All of those are misdemeanors except that last charge, that scheme to defraud is a felony charge. I read the complaint. Again, there is probable cause for the charges, Ms. Atkins. I've also looked at your criminal history. You've got several prior charges. So you're probably gonna get a bond, but I'm gonna listen to the attorneys before I make a final decision. Mr. McDaniel, anything on behalf of Ms. Atkins?
Your Honor, we just asked the court to consider conditional release. I don't think she has much of a criminal history. She also is, has some medical issues. I think she's,
I'm going through another
correct.
top. I'm sorry.
Can you let me?
Yeah,
So,
absolutely,
Your Honor,
sir.
I think she's, you know, maybe have a, deceased baby in her that they're trying to get out right now. So they're got surgery and stuff planned up the next few days for that, emergency surgeries for the baby and whatnot.
Okay. I'm sorry to hear that. Ms. Atkins, the criminal history I've got shows nothing in Florida, but in Indiana, I'm showing close
Yes,
to 10
sir.
arrests. Is that wrong?
I haven't been in trouble for almost 6-7 years.
You've totally
And I-
ignored
and
the
I-
question. You've totally ignored the question. I'm showing about 10 arrests. Is that wrong?
I don't know if about 10, but yeah, I got like 6.
Last charge being 2020, false information and driving while license suspended. Is that the last time you've been in trouble?
Yes, sir.
Okay. 5 years ago. Mr. Mitchell, anything from the state?
Just a reasonable bond under the circumstances.
So Ms. Atkins, I'm going to set you a bond. Your bond's going to be $5,000 on the felony, $1,000 each on your 7 misdemeanors. Your total bond is $12,000 cash or surety. I don't have a problem with a medical furlough if that's appropriate. So Corporal, if the medical furlough is what we need to do in this situation, someone let me and Mr. McDaniel and Mr. Mitchell know the details. And if that needs to happen according to your medical staff there at the jail, obviously we'll need to try to make that happen if it's appropriate. So in the meantime, you've got a bond of $12,000 cash or surety. You do have a condition of absolutely no contact with any Walmart while this case is pending, Ms. Atkins, because of the type of charge you have. You will get to use the phone in just a few minutes, ma'am, and the medical staff should be seeing you sometime shortly. Ms. Atkins, do you have any questions?
No, sir.
As far as the court date, are we still on the January 6th cycle? The jail's gonna give you a notice for your court date. That'll be January 6th in circuit court, ma'am. That'd be at 8:30 a.m. Wish you the best.
And Your Honor, I
Thank
guess I
you.
will just state the state has no objection to a medical furlough. So
Thank you. All right, wish you the best, ma'am.
Thank you.
Yes, ma'am. Luis Sanabria Canas.
We don't have an interpreter here yet, so we're going down to David.
Was there an interpreter request done? I haven't seen
Yes.
one.
I was told that.
They're working on it right now. I just talked to them. They're working on getting one right now.
So was there an interpreter request done, Sergeant?
Yes. I did do one, but I forgot to email it. So that was just done in the last couple minutes, and I called and spoke to them at the courthouse, so they're working on getting one right now.
Okay. Mr. Sanabria Canas, do you request the services of an interpreter? Do you speak English, sir?
This is David. They don't speak English.
Okay.
Neither.
This is David I'm sorry. How do you pronounce your last name, sir?
Prokopchuk.
Prokopchuk. It's not
Yes,
hard
sir.
when you do it slowly. Prokopchuk. Mr. Prokopchuk, you're here in case 25-501, and the charge is confusing because the charge as filed just says
It's
failure to pay
it's
civil
a
fine. Yeah,
it's
so-
$105 fishing ticket, your officer. Your Honor.
So hang on just a second before we get to that. My question, Don, is it appropriately set up? Why would it not say the charge? Why would it just say failure to pay fine? That doesn't seem like that makes.
Right. Yeah, it was just.
Just a second. I'm asking the clerk a question.
say what the actual
Right.
charge is, but I wasn't here the day that they transferred it, and they had to set up one, no expired official, no expired official license, we had one for money. So anyway, that's the way they put it up, but I'll just tell this what it needs to have it.
So what is the actual charge?
No or expired official license.
No expired fishing license, and it was civil originally, but when you don't pay it, it becomes criminal. Okay, so that's what you're accused of, sir. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to David. He's made a plea of no contest. The charge is listed. The understanding that it'd be, he'll serve 4 days in county jail. He'll have credit for 4 days. He'll get out this morning. There'll be a $370 fine, or whatever the court sets for a fine. And I advised him that he needs to make sure he makes that payment at the clerk's office within 60 days or set up a payment arrangement, or they're going to suspend his license.
Well, considering the amount of time you spent in jail, I'm inclined to just impose the original fine, not the regular court costs and fines. What was the original fine amount?
105.
105?
Yes.
Mr. Mitchell, any objection to that?
No objection.
Sir, do you have any questions about that agreement?
No, sir. It's $105 will be the payment.
Right.
Yes, sir.
And what'll
Yes,
happen
sir.
is if you don't pay that, you can't go to jail for not paying it because you've already served the jail sentence, the criminal case is over. But if you don't pay it, your driver's license very well may be suspended. That's why you've got to pay it within 60 days.
Yes, sir. And it's $105.
Is it 60 or 90? Before y'all suspend a driver's license? It's 90 days before they suspend your driver's license, and yes, it's $105, the same amount earlier. I'm not adding the normal criminal court costs and fines because you spent this time in jail. Okay.
Yes.
I think everyone thought when we set the bond, we thought you'd post the bond and it'd be over with essentially, but that didn't work out in that manner. So is this the plea you would like to enter?
Yes, sir. Guilty. Yes, sir.
I want to accept your plea of plea of guilty then to the charge of no or expired fishing license, which became a criminal charge. I'm going to withhold adjudication of guilt. I'm going to sentence you to 4 days in jail, but give you credit for 4 days you've already served. It's a time served sentence. There are court costs and fines. There'll be court costs in the amount of $105. And as I've explained, the clerk's office will suspend your driver's license if you don't pay that under Florida statute. So, sir, what's going to happen is they're going to do a warrant check for you. I'm not aware of anything else. As long as you're not wanted anywhere else, you're going to be released this morning. Just take care of that within 90 days, or your license may be suspended. Do you have any questions?
No, sir.
All right, sir. Wish you the best. We have Johnny Gore. Mr. Gore, good morning. Mr. Gore, you're here because you're wanted out of the state of Georgia. Mr. Gore, I believe you're just here to see if you want to sign a waiver of extradition. That may be what Mr. McDaniel's got there in front of you. All right. Mr. Gore, I see you just signed that. Do you have any questions about the waiver of extradition process?
I don't know, sir. Like,
Not about the case, but
my
about the waiver.
understanding, this is supposed to be over with, but I don't know what's going on.
Okay. Do you have any questions about the waiver of extradition process? That's what you're here for today. I'm not the judge in your case. I'm just deciding if
Oh,
you.
no, sir.
if you're-
I'm just trying to see how long they had to come get me.
Okay, so I want to make sure you're voluntarily waiving extradition. They have 30 days to pick you up under state laws. The two states work under the same law, but it's very rare for them to take that long. Mr. McDaniel, my sheet
Seminole County
didn't say
generally
what county in Georgia, what county, how far in Georgia, up, how far in North Georgia?
Seminole, so it should, they usually less than a week, but it is Christmas, so I mean, I don't know, it could be a week.
So Mr. Gore, with Seminole County, as Mr. McDaniel said, normally you're talking a few working days, but it is Christmas week. So if you're still here in 15 days, I'll see you again. That's very, very rare for you to still be here in 15 days. If you are, though, we'll see you, and I'll ask the jail what's the latest with the transport, and you'll get to hear that answer. There's a good chance you'll have already be gone before 15 days. There's a good chance you'll be up there this week. They'll be notified today to come pick you up now that you've signed the waiver in front of a judge. Do you have any questions?
No, sir.
All right, sir. Have a good day. Okay, so that's it, except for our two non-English speaking individuals. So all I know to do on those is I have nothing on an interpreter, and it could be it could be an hour. So all we can do on those cases is see them tomorrow. Who is this, Mr. McDaniel? Which case is
Oh,
this?
that's the two Hispanic ones, since you were talking about.
Okay. So do either of you speak English? No. ¿Habla inglés? Okay.
A little. Poquito.
Okay. Habla un poco de español. Un poco.
Okay.
Pero, por favor, hable despacio. Despacio para que yo pueda entender. ¿Entiende?
Okay. Sí.
Okay, so I said I speak a little Spanish, a little, but please speak slowly so that I can understand. No interprete aquí today. ¿Entiende?
Sí.
Un momento, Judge. We might be able to bring.
Un momento, por favor.
If you want to do that.
Tendremos un intérprete aquí en un momento. Puede, possibly.
I would probably get Lawrence to see if he could give us his services again, but he's not here today. Yeah, they had the baby. Little Lawrence Jr.
Jake, or somebody want to ask Amber and see if like they got somebody coming right now, or if not, then.
Well,
I don't think the jail, if the jail does one 5 minutes before it starts, and our primary translator, Mr. Ricardo, is out on medical leave, it's almost impossible to get one set up that quick. So it's just, it happened too late to have it happen. So the only way it's going to work is if we have somebody in the courthouse who speaks a lot better Spanish than I do, which isn't a high bar, but it's.
Stacy not there today?
Mr. Goodson is here. How's your Spanish, Mr. Goodson?
no muy bien.
He says as a probation officer, he has perfected the phrase no cervezas, but that's about it.
That's fine. Make it quick.
I guess while we're waiting for him to get up, do you want to talk about this?
Just a second. No, I don't. Take me just a second. So we do have an interpreter on the way. Okay. Tendremos un interpreter aquí en un momento. Entiendo? Okay.
Sí.
So while we're waiting, Mr. Mitchell, there are 2 cases set for this afternoon. Is that correct?
Yeah, it was
Let me get my calendar pulled up here and see what we got.
status conference for those old cases, old CT cases.
What time are they at?
They were set for 1:30 according to the email that Pamela sent me and Taylor.
Down. I'm only showing 1 on the calendar.
Is that our interpreter?
Yes, sir. Good morning. How are you, Judge?
Oh,
We let him, hey, good morning. We let him know that we've got an interpreter, please. Good morning, ma'am. Thank you, and apologize for the last minute notice. We had a mix up this morning. Can I get your name, please?
Yes, sir. No worries. Sarah Bear, Judge.
All right, Ms. Bear, thank you. My understanding is you're fluent in Albanian Swiss. Is that correct?
No, sir. I am fluent in Portuguese and Spanish. They told me it was for a Spanish interpreter.
It is for Spanish interpreter. I was just joking. So we have 2 individuals this morning. We have Luis Sanabria Canas y Sergio Quijada Mejia, excuse me. So let me start with Mr. Sanabria Canas. If you please introduce yourself to them in Spanish and make sure they can hear you, please, ma'am.
Yes, sir. Buenos días, señores. Yo voy a ser la intérprete para ustedes hoy. Creo que esta es una primera apariencia. Me llamo Sara y vamos a empezar.
Okay.
¿Me pueden oír bien?
Sí.
Yes, they can hear me, Judge.
Mr. Sanabria Canas, we'll start with you.
Señor Sanabria, vamos a empezar contigo.
Okay.
You're accused of 1 count of obstructing an officer without violence.
Tú estás acusada de un conto de, de impedir el policial sin violencia.
Okay.
You have a bond that's already been set by a judge over the weekend.
Usted tiene una fianza que ya te fue puesta por un juez en este fin de semana que pasó.
Sí.
And you're here today to be made an offer and also to have an attorney appointed if you ask for one.
Y hoy estás ahí presente, te van a hacer una oferta al Estado y también te van a presentar un abogado si necesitas uno.
Mr. McDaniel, are you indicating there's an agreement reached?
There is, Your Honor.
Preguntó si ya llegaron a un acuerdo, dijo que sí, que ya llegaron a un acuerdo.
Sí.
I'm appointing the public defender's officer to represent you. Please listen to your attorney.
Yo voy a apuntar a un defensor público para poder ser a tu abogado. Por favor, hazle caso.
Okay. Your Honor, I've spoken to Lewis. He's going to enter a plea of no contest with the understanding he'll be sentenced to 60 days in jail, 2 days jail
One
credit.
second. Señor, le expliqué a él que va a hacer un acuerdo con el Estado que no va a contestar. And I'm so sorry, counsel, you said the plea was for how much jail time?
60 days with 2 credit.
Okay. Va a ser un acuerdo sin contesto y vas a pasar 60 días en la cárcel y te van a dar crédito de 2 días que ya serviste.
Okay.
Okay.
There'll be a $370 fine.
Tendrá una multa de $370.
Waiving his right to a jury trial and call witnesses at that trial.
Él abrió mano de su derecho de tener un juzgamento con testimonios y con cualquier otro procedimiento.
He understands that any conviction can result in ICE deportation.
Y él también entiende que cualquier convicción que le pase puede resultar en el ser deportado.
That'll resolve this case this morning.
Y esto va a resolver este caso en particular esta mañana.
Okay.
Mr. Mitchell, is that plea agreeable with the state?
It is, Your Honor.
Sí. Señor Mitchell, ¿el Estado está de acuerdo con esto? Sí, el Estado está de acuerdo.
Mr. Sanabria, did you hear that agreement?
Señor Sanabria, ¿usted oyó este acuerdo que hicieron?
Sí.
Yes.
Do you have any questions about that agreement?
¿Usted tiene alguna pregunta sobre este acuerdo?
No, está bien.
No, it's okay.
Is that the plea you would like to enter, sir?
Y es el testado que usted quiere hacer.
Sí, estoy confundido porque me pusieron 30 días de más a mí. Porque
Yeah, I'm
manejar.
confused because they told me it was 30 days because I was driving.
Offer made to you this morning based upon your prior history of 60 days in the Jackson County Jail.
Te recuerdo esta mañana que por cada tiene un histórico anterior será 60 días en la cárcel del condado.
You appear to have prior criminal history in the United States. Mr. Quijada does not.
Porque tú tienes precedente criminal en los Estados Unidos. El otro señor no.
His offer is 30 days.
La oferta de él es de 30 días porque no tiene ningún histórico criminal en el país anterior. Pero tú sí.
You do not have to take this offer. You can post the bond that's been set for you if you wish.
Usted no tiene que aceptar la oferta si no quiere. Si quiere postar la fianza y salir y ir a juicio, puede.
¿Puedo pagar mi fianza y salir?
I can pay my fine and leave.
You can post the bond, but the Immigration Service has a detainer placed on you, so you'll be released into their custody.
Usted sí puede pagar la fianza, pero la inmigración tiene una detención en tu contra. Entonces, aunque pague la fianza, te van a libertar, pero la custodia de la inmigración.
No importa, yo si me mandan para mi país me voy, pero yo no quiero estar así. Mis hijos me necesitan.
It doesn't matter to me. If I get deported and I have to go, then I go. My children need me.
I have no idea if you'll get deported or not. I'm only the judge in the resisting without violence case.
Yo no tengo ninguna idea si sí te van a deportar o no. Yo solo soy el juez en el caso que de esta resistencia al arresto sin violencia con el policial.
So in that case, do you want, in that case, in the resisting case, do you want to post the bond or do you want to take the plea offer?
Entonces, en el caso, para resolver solo el problema o la cuestión de que resististe al arresto con el policía, ¿quieres pagar la fianza o quieres aceptar el acuerdo del Estado?
Quiero pagar mi fianza.
Yes, I want to pay my bond.
Your bond is $3,500 cash or surety. Have a good day.
La fianza es $3,500, sea en dinero o con propiedades. Que tenga buen día.
Okay.
Mr. Quijada, you're here because you have the exact same charge.
Señor Fijada, estás aquí porque tienes el mismo cargo.
That is resisting an officer without violence.
Resististe a detención sin violencia.
I'm going to appoint the public defender's office to represent you this morning
Yo voy a apuntar al Estado que te dé un defensor público esta mañana
and ask that you listen to your attorney, Mr. McDaniel.
y pedir que por favor hazle caso a tu abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Sergio, but let me ask him again.
Señor juez, había hablado con el señor Sergio, pero déjame preguntarle una vez más.
Do you want to post the $3,500 bond or do you want to accept the 30 days in jail?
¿Usted quiere pagar la fianza de $3,500 o quiere aceptar el 30 días en la cadena?
Yo quiero pagar la fianza, pero no tengo ningún número, no me acuerdo ni un número. Ellos agarraron el número de mi señora aquí, pero no me lo quieren dar.
I want to pay the bond, but I don't have anybody's phone number. They took my phone. I don't have my lady's number to call her.
If you choose the bond, you have the right to use the phone. I can't control what phone number you have access to.
Si tú eliges pagar la fianza, sí puedes hacer una llamada, pero yo no tengo control sobre cuál número usted tenga acceso o no.
So you have the bond set by the weekend judge. You will get to use the phone shortly.
Entonces te dieron el tanto de la fianza por el juez del fin de semana y vas a poder utilizar el teléfono en un rato.
Corporal, in both of these cases, we need to give them a notice for their January court date.
Y en los dos casos le dimos una noticia del día de la corte en enero.
January 6th at 9 a.m. will be their court date.
El día 6 de enero a las 9 de la mañana va a ser el próximo día que tenga que presentarse perante la corte.
Have a good day, Mr. Chiara.
Tenga un buen día, señor Chiara.
Gracias.
Thank you.
Thank you. Madam Interpreter, thank you very much, ma'am.
My pleasure, Judge. Happy holidays to you.
Same to you. All right, Mr. McDaniel, that's it as far as I know. Anything else from the Public Defender's Office this morning?
No, Your Honor.
Your Honor.
Yes, thank you, Vivian.
Thank you. Have a good day. Merry Christmas.
Thank you, you too. Hopefully that's all we'll need today. Thanks. Good morning, sir. Are you Donnie Buchanan?
Yes, I am, sir.
Welcome to Centerville. You got a ticket on December 1st for driving without insurance. You get lots and lots of these. Wow. Vivian, Laura, I'm out of register of actions. How did that happen? Anyway, no insurance is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Excuse me, up to $500. Carries not less than $200 fine plus cost. I ask everybody the same question. Do you have insurance now?
Yes, I do, Your Honor.
You have proof with you?
Yes, I do.
All right. Who's your carrier?
State Farm.
All right. We have some pretrials this morning that the prosecutor is doing. I'm gonna see if I can get them to do a pretrial on this, yes?
I made a note. I've already talked to Prosecutor
Okay.
Gary. He is offering the civil infraction.
Oh, good. Who'd you talk to?
Gary.
Thank you, Gary. He seems to be the only one that comes in early. Thank you very much, Gary. We get lots of these, as in dozens or hundreds. Probably by the end of the year, we'll have several hundred of these. It's a heavy duty charge. It's under the insurance code rather than the motor vehicle code. The minimum fine is $325. It's a misdemeanor punishable by up to a year in jail, and it requires that you get fingerprinted. About 80% of the time, the people are like you. They come in and now show that they have insurance. What the prosecutor will do with those is dismiss the original charge and turn it into a civil infraction known as no proof of insurance. That means you didn't have the slip in the car. That carries a fine of $150. It's not a crime, it's a civil infraction. And it doesn't carry as much damage to your car insurance. Are you willing to plead to that lesser charge of no proof of insurance?
Yes, I am, Your Honor.
All right, very good. In fact, when you plead to that, you don't even, it's not a guilty plea because it's not a crime. You admit. State Farm. They can now run your plate and see whether you have insurance. Laura, I'm running out of envelopes too. And so they pull people over by the dozens who are driving around with no insurance. It's very expensive if you get in a car accident with no insurance because you're not covered by the no fault statute. It also kills your insurance rates. Anyway, on that day, December 1st, did you not have proof that in the car that you had insurance?
No, I did not, Your Honor.
All right, the fine is $150. I'm gonna make that due by February 1st, 26. That's much less onerous than 325. 252494 SM. You can use a credit card to pay this, send in a certified check or money order, or bring in green cash.
Okay,
But you're good to go.
all right, thank you.
All right, thank you. I'm glad you're insured. Thank you. Oh, Abigail? All right. Year end, running out of everything. All right, we're plugging away. I don't see Michael Blasius. Oh, the other Michael Blasius. Okay, come on up. Your dad and I go back a long way, and I was hoping it wasn't him, but unfortunately it's you. This is file 252336. We go back a long way.
Yes, sir.
You got a ticket on 11/12 at 5:56 a.m. at 131 on Lovers Lane for driving suspended. What 5:56 a.m. tells me is that you were on your way to work. Your license is suspended. For a bunch of stuff. Boy, you've had a bunch of accidents. Non-alcohol accidents.
Yes, sir.
But they suspended your license in 24. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 2 points on your driving record and requires that your license be further suspended. How do you plead to that charge?
Yeah, guilty.
All right, you want me to appoint a lawyer to help you with this?
Yes, sir.
You have 6 points on your license. Now, this was November 12th. There was apparently an accident. You had another accident on October 23rd in Kalamazoo. Another accident in Kalamazoo in July. And a driving suspended here last January. And another accident in Kalamazoo in 23. Wow, another accident here in 23. How many accidents you been in?
That's it, Your Honor.
About 10. 22 crash. 80 and a 70. 18 crash. Holy smokes. All right. There was an accident this day?
Just went in the ditch.
All right,
No two-car collision or anything.
all right. Appoint an attorney. How'd you get here?
My brother-in-law.
All right. Set attorney pretrial for February 6th. At 8:30. I don't think you owe us any money.
I owe back restitution, but I pay on it every month.
Do you?
Yes, sir.
All right. Well, this wasn't good. I'm guessing at 6 o'clock in the morning you were going to work, but I don't know that. But you were supposed to be driving. You keep crashing, so the state took your license away. All right, you go out, we'll get a lawyer to help you with this.
Thank you.
All right, good luck, sir.
Thank you.
Tell your dad I'm glad it wasn't him. Sorry it was you, but I'm glad it wasn't him. All right. Matthew Samansky. Good morning, sir.
Good morning, Your Honor. You did very well with the last name, I must admit.
What?
You did very well with the last name. I
All
have
right,
to
well, good. I mess a lot of names up. The names are important. 252388 SM. You got charged also with no insurance.
That is correct, Your
Do you
Honor.
have insurance now?
I do.
Ms. Jackson, did you get a chance to talk to anybody on this?
Yes, I talked to him at the same time. He has the same offer for civil infraction.
Very good. Thank you, Ms. Jackson. I greatly appreciate that. And thank you to Mr. Gabry for dealing with these. I had that nightmare day when I had to have 7 people all come back. Who's your carrier?
It's Progressive, Your Honor.
Were you driving a car on November 19th and you didn't have the valid slip in your car?
That is correct, Your Honor.
But you do have it now.
Yes, Your Honor.
All right, as you heard me tell the last guy, this is $150 as opposed to $325. Fine and cost is $150, and that is due by February 1st. Can you pay it by then?
By then, yes, Your Honor.
All right, if you need more time, come see us, but this is a civil infraction, not a crime. There's instructions in here on how to pay by online. All right, you're good to go.
Thank you, Your Honor.
Good luck, sir. And if you keep your insurance on there, you won't have to come see me anymore.
That's the plan, Your Honor.
All right, good. That's a good plan.
Okay, I've got my eyes on a bunch of different courtrooms around the country. It's a bit of a mixed bag today, as you would expect on a holiday week. There's some courts that are running, some courts that aren't. Kind of what I expected. Let's change it up a little bit, though. We'll stay in Michigan, but let's say good morning to Judge Elmore. I think he's going to do a sentencing.
Petrie, am I saying that right? Yes, sir. Thank you. This is file number 25-14151FH. Appearances from counsel, please.
Joanna Carey for the people.
Allison Cass on behalf of Mr. Petrie.
Thank you.
Honor Lisa Satawa, always also on behalf of Mr. Petrie.
Thank you. Mr. Petrie is here in person, and also here in person is the agent from the Department of Corrections who prepared today's pre-sentence investigation report, Mr. Stephen Saladay. We are here today for a sentencing in this case. The defendant entered a plea back on November 24th to a single count of use of methamphetamine as a second or subsequent offender. Let me take a quick look here at the PSI. Any notes on it? That's pretty rare. Must not have seen it. One moment. All right, Ms. Carey, did you receive it? And if so, did you have any amendments, corrections, or objections to make?
Thank you. I did receive and review it. I don't have any corrections or additions. Thank you.
All right, same question for whichever one of the two is going to talk on behalf of the defendant.
Yes, briefly, to clarify, in one point of the PSI, it stated the recommendation was to 18 months, and another it was to a year and 8 months. And then the third section, it was to 18 months. So I'd be asking for clarification on probations.
Yeah, no problem. I assume, Mr. Saladay, you meant on CFJ 145, page 2, that would be 6 months.
Yeah, it should be 18 months pro, yes.
Yeah,
Yes.
1 year and 6 months.
Correct.
All right, we got that one. Okay.
And next being,
Anything else?
yes, looking at page 9, looking at the employment section, prior to his drug use, Mr. Petrie advised that he was working 4 jobs from 2014 to approximately 2016.
Good, all right. And do you want to provide me any other detail there? You said
I would
for-
defer to Mr. Petrie.
All right, Mr. Petrie, it sounds like you had some other employment. Right now, it's got listed as Northern Staffing.
Yeah, I did the last 10 years only. I didn't do like anything, all that. I worked at Pompey's in Baldwin since 2006 to 2018.
Okay, hold on. Pompey's, that's a pizza place?
Yes.
And that was 2014 to
2006 to 2018.
I'm sorry, I misunderstood you.
Sorry.
2018, copy that.
And then to Reed City Pompey's 2011 to 2013.
2011 to 2013?
Yep.
Okay, so you worked at 2 different places in the same business.
Yeah, same business. And then the Everett one, I helped establish the Everett one. Everett one too.
And what was that?
In between, like, so probably 2012 to 2014.
All right, we can add those, and it sounds like they're overlapping, and obviously it's all good for the same kind of business. Did you get all that, Mr. Saladay?
Yeah.
All right, thank you. Back to you, Ms. Castle.
And then just to clarify regarding his substance use, as that is the offense he's being sentenced on today, his THC use, he advised that he quit using that altogether in 2013 when his son was 2 years old. That's what caused him to become sober from marijuana.
Okay, all right. We can go ahead and make that change. Thank you. Hold on, let me double check to make sure that not only are we talking on CFJ 145, page 1, but also in CFJ 284, and that would be page 10. Yeah, so we'll have to change that also on page 10. All right. That Mr. Saladin? I do. Next, Ms. Castle?
And yes, that is it.
Thank you very much. Give me just a moment to refresh my recollection. All right, Ms. Castle, allocation.
Thank you. We would be asking that the court adopt the recommendation put forth by probation. However, without him being sentenced to jail for the remainder of the term, he's been in custody for 57 days. Mr. Petrie was accepted into a 30-day residential treatment program addressing his substance abuse issues. When he was arrested for this event, he was experiencing a relapse. Prior to being arrested, he was successfully sober for 9 months. He had gone through treatment at Harbor Hall, as the report notes. However, he did leave early. His reason for doing so was that he was confident in his sobriety without it, and that he missed his son. And now what's changed is he's ready to move forward. He's ready, knowing that he can't do this by himself. He's explained to me that he understands the significance of community that he had when he was actively engaging in treatment, and he desperately wants that. He wants to get back to working the way that he was prior to his substance abuse taking off. He wants to be the father that his son deserves, and he's asking that the court give him that chance by ordering him to treatment, as well as the term of probation to keep him accountable.
All right, thank you. Ms. Carey, on behalf of the people.
Thank you. I am somewhat reluctant, but I'm going to ask the court also to follow the recommendation. And when I say I'm reluctant, it's because you look at the PSI, it says he's had very little work history over the last couple of years. He has mental health conditions that are currently untreated, and a long history of substance abuse, and the fact that he left Harbor Hall already before he completed is troubling. And I understand that now he knows he can't do it on his own. I hope that's true, and I hope he can show that moving forward. However, his history is not terrific, but I understand the guidelines, and I understand what the plea agreement was in this case and the reasons for that. So I am going to ask the court to do the jail sentence with probation. Thank you.
All right, thank you. Mr. Petrie, I want to find out an answer to a question before I turn it over to you. 1 second, please. There it is. Mr. Petrie, I want to ask this question. I want to make sure it says, I know you have a son. Do you just have the one son?
Yes.
All right, I just want to make sure we're talking about the same. And what's your custodial relationship with your
I
son?
have full custody of my son. My sister has temporary power of attorney right now. And
All right. How long have you had that full?
since he was 3 years old.
All right. All right, sir, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say?
If I'm able to go and leave to rehab, I'm like Mike Lloyd said, I'm very serious about it. I'm going to seek transitional housing and stuff after the fact. Regardless on what happened to you today, I'm still going to go to rehab.
Mr. Saladin, are you aware of this rehab and have you confirmed it or don't know anything about it?
First time I've heard of that.
All right.
You expressed it, please. expressed
me, Your
an
Honor.
interest in it.
Oh, yep, hold on.
He expressed an interest in it, but nothing had been set up at the time of the PSI interview, which was about 5 weeks.
Your Honor, I just want to
Sure.
confirm that you received the letter from the facility that was sent to your court and sent to send to the prosecutor.
When was it sent?
I spoke to them on Friday. We were, they confirmed that it was sent to the court as well as the prosecutor's office. They sent it to us by fax on November 19th.
Yeah, we'll take just a brief recess in place. I don't have it. I'll go check my office.
Okay, well, we wait for him to come back. Let's go back to Judge Middleton. And he is doing absolutely nothing exciting, but that's okay because Judge Elmore just got back.
I do not have any letter. Ms. Carey, did you get one in your email?
No.
Yeah, all right. Okay. All right, well, one moment. I'm going to get back to what I was reviewing a moment ago. All right. Well, let's take a look here. I look here at the agent's description of offense. Oh, by the way, Mr. Saladay, in the middle, on CFJ 284, page 2, in the middle of the large paragraph underneath description of the offense. On the 6th line down, 2/3 of the way through, it's got a misspelling. I assume that means he.
Yes, Your Honor.
All right, no problem. And this is the case where Mr. Petrie identified himself as a Daniel Howell, correct? Yeah, so he, and I know that was already acknowledged in the scoring of the guidelines, specifically offense variable number 19. One moment. Then.
No,
No.
no, Your Honor, that's wrong. I'm sorry.
Yeah.
How was another person in the vehicle?
Okay, all right.
He just didn't provide his identification
Okay.
or name up front, and they had to take a picture of him to identify him at the shelter.
All right, so that is how, not he.
Right.
All right, good. I just wanted to make sure we got that right. See, in my pointers, there's multiple people in the vehicle. And when I look at the agent's description of the offense, got in the vehicle without knowing an individual fully. And then I relapsed. It looks to me like Mr. Petrie was already putting himself in a bad position by getting into this vehicle with people who clearly were lying, parked behind a church. I don't know what he thought he was getting himself into. And it's not like he just relapsed there in the car. I mean, clearly he put himself in this position, or I think a reasonable person or at least a reasonable person in his position would know he was likely not in the right place. One moment. And I recall reading this last week. 1 second. At the bottom of CFJ 284, page 3, this is Mr. Petrie saying he just gotten a job, had a backpack, and then inside he had a magnetic case. Had the cards with the syringes. To me, it sounds like you brought the meth to the car.
Yeah.
No? All right. Well, take a look here at the defendant's criminal history. It began in 2005, although relatively minor, no operator or no license on his person. He had a pretty good year, 6-year gap or so until he picked up another charge. Not that big of a deal, but it does have to do with the crime of dishonesty, having welfare fraud. He then made it about 8 years, but that case was dismissed. So actuality, he made it 9 years until 2020, where he was picked up while on bond and picked up another crime of dishonesty involving an embezzlement. And then while that case was pending, literally 2 weeks later, while still on bond, he picks up yet another charge, and that's for meth. And then he makes it 9 months before he picks up operating without his insurance and an unregistered vehicle. Not a big deal, but that means that the defendant here, knowing that he apparently has just gotten out of jail, he will do what he wants if he thinks he can't get caught sometimes. And then we have a gap in time from May of 2022 until January of 2023, so about 8 months. And then while in this case, he picks up a drug case, he absconds on probation twice. Well, he was supposed to do probation for 2 years, and looks like he only made it a year because he was in an absconder status. And then after that case, he made it a year until he picked up this case. And I appreciate Mr. Petrie, the interest in your son, but your son's 14. Your son was there when you picked up this case. Your son was there in your life when you picked up the drug case in 2023. Your son was there in the case just before that, the one before that, where you picked up another drug case, and your son was there for you when you were convicted of embezzling or stealing from a vulnerable adult. So what's different today? That's my key question.
What's different today from different today than then is, in retrospect, I messed up. I get that, but I'm ready to do it for me. I was just trying to do it for selfish reasons, and I was living life for me. I was trying to do this for me. I'm tired of living this lifestyle. That's what it falls down to.
I mean, you had just gotten out of rehab 6 months before. But you didn't complete the program because you left it.
I got my 30-day check though for doing what I was supposed to do.
Okay, all right. I'm glad to hear that. But you left the treatment program without completing it. And that's the only time you've taken a treatment program, at least according to the pre-sentence investigation report.
Yeah, at the time, like I said, like Ms. Castle said, I felt as if I was trying to do without that kind of.
Yeah.
But like the mechanic there was just not my style, I guess.
Yeah, I hear that one. The mechanic.
Yeah, like there's a ranking system. It's very cultish.
At the treatment program.
Yeah, the treatment program.
Yeah. Well, that wasn't a court, or was that a court order program?
No, that one in court.
All right. Now, we don't need to talk about all these in detail here, but in this report, I see that there are some health problems that you've got. And I don't see any medication or treatment issues.
I just like, when I was at Harvard Hall, the therapist or whatever you want to call him, he diagnosed me with those issues.
Yeah.
Every time I went to CMH right after that, after I left Harvard Hall, to try to get some help for it, and they told me I was very functional, that I didn't need it.
All right. Well,
I was in Osceola County.
Okay. All right. Well, here's the sentence of the report. First of all, I
Excuse me, Your
acknowledge.
Honor.
Yep.
I located the facts from the treatment facility. Would the court like me to forward it right now?
Yes, you may, but I know what I'm going to do, though. I mean, I'm going to allow him to get into the treatment program, but it's going to be set up and run through probation, because I need probation to order him into the program, because that way, if you leave the program, then that's a violation. And then if you leave it, you're gone for more than a certain number of days, which is 60, then that becomes a non-technical violation. And non-technical violations is a lot more on what to do. So I'm just going to ask Ms. Satawa to go ahead and send it to us, and she can email it to the court. Make sure it gets to Mr. Saladay, and Mr. Saladay can confirm it and get him into the program. Did it have a start date, Ms. Satawa?
Oh, let me pull it right back up. It is dated November 19th. It says, to whom it may concern, this letter is to confirm that Cody Petrie, his date of birth has been approved at Addiction Treatment Services 30-day men's residential treatment program. I'm going to mispronounce this word, but Dukoski Hall, that has an address in Traverse City. It does not have a start date.
All right, you got it right. All right, so here's what the sentence of the court is today. The court sentences the defendant to a period of probation for, I'm going to say 24 months. The court adopts the terms and conditions for probation that are listed inside the PSI and CFJ 145 pages 2 and 3. I find that those terms and conditions are well suited for rehabilitative purposes based upon the defendant's history involving controlled substances and other substances such as alcohol and marijuana. I thought alcohol was listed on it. No, it wasn't listed on there, but still a variety of controlled substances. And therefore, if a person's going to abuse one, I'm concerned that they might abuse another one. So therefore, that applies to alcohol and recreational marijuana. The court sentences the defendant to a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. We have DNA here. I don't remember if he had. Oh, he had a prior felony.
No DNA fee.
Yep. A supervision fee of $30 a month or $60 a month if there is any electronic monitoring. The court acknowledges that this is a intermediate sanctioned cell. However, the court does find reasonable grounds for some period of jail, specifically the times where he has been he has violated bond, where he has absconded from probation, and that we have repetitive repetitive controlled substance cases, including, I think at least 2 of them were methamphetamine. So the court sentences the defendant to 90 days with 57 days of credit. And the court's going to ask the probation office and tell them, if you can get him into treatment ASAP, then we'll release you early to get you into the treatment program, okay? Now, you want to make sure you complete that program. You want to make sure that you invest all of your time in it. You do not want to leave early. If you leave early because you don't like the way someone smells, looks, or smiles, I do not care. All right, you've got to do the program. Have I missed anything, Mr. Saladay?
No, Your Honor.
Ms. Carey?
No, thank you.
Fence team? Mr.
No, Your
Stover,
Honor.
All right, thank you very much. All right, 1 second here. Oh, I find that the sentence is reasonably proportional based upon the factors I discussed and the contents of the pre-sentence investigation report. 1 moment. Samantha, are you gonna run this over to him? One of you? I'm bringing out you 2 copies of 1 document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you have there with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. You have the right to be considered for early release from your probation at halftime. So if you have been compliant after a year, then you have the right to be released from your probation early. All fines and costs are due within 56 days, or the court can add a 20% penalty. That penalty can be removed by the court as long as you make payments by the end of your probation. So if you want to be off of probation early, you got to pay them early. Does it make sense?
Mr. Chairman,
All right. Mr. Petrie, how old are you?
I am 40.
Yeah, 40. You're old enough to know. You got a kid. I guarantee you he knows what's going on. Obviously, he knows what's going on with you and your life and your choices. It's about time to set an example, because if you don't, I hate to see him up in a court doing the same stuff. Kids pay attention and learn from their parents, okay? And let's hope that you can teach your son how to handle this issue and how to overcome it, okay? If not, I hate to think of it, but he will end up here in court someday too, okay? So don't beat yourself up for that part. Only beat yourself up if you ever go back and start using it again, because then, away. All right. All right. Good luck to you, Mr. Petrie. Thank you all very much. We are adjourned.
Let's go to Michigan, spend some time with Judge Mom.
So that's not new information to this court. This court knows that your client travels out of state for work. Given the significant allegations that are present in this matter, the court has serious concerns for the safety of the public, even the public that's not within this location or the state of Michigan. And your client had previously relocated and was not living at the home when these allegations occurred. So your client wasn't residing, your client was residing with your dad at the time, with his dad at the time of these allegations as well. And counsel, I understand that your client may have work obligations that take him out of the state of Michigan, but this court has some serious concerns for the safety of the public, given these allegations that have occurred.
May I propose
And-
this?
Just one moment, just one moment, counsel. I'm just waiting for the prosecutor to come in to place that on the record, his opinion regarding Mr. Miller's ability to travel out of the state, given the nature of these charges. Counsel, your appearance for the record, please.
Good morning, Your Honor. Stephen Campbell on behalf of the people.
Good morning. And there's a request by Mr. Coyle to allow his client to travel out of state for work purposes.
Your Honor, if I may.
Yes.
So Mr. Coyle and I had a conversation regarding that issue, and the people view it from this perspective that it's good for his client to work. We don't think he's going to vanish, Your Honor. I think Mr. Coyle has good client control. Therefore, we would not object.
Okay, and counsel, I can appreciate that. However, while it may be good for Mr. Miller to work, it's also, given the nature of these allegations, the seriously disturbing allegations that are present in this case, the court has significant concerns for the safety of the public at large, whether Mr. Miller is in the state of Michigan or elsewhere.
Of course.
So the court's not inclined to grant that request. You had one other thing you wanted to address, Mr. Coyle?
Yes, I was going to suggest this as a proposal. Can we attach Mr. Miller somehow, some way to pretrial services, and those times when he needs to leave the state of Michigan for his employment, let pretrial services know when he's leaving and when he's coming back. I understand the court's concern with regard to safety of all people.
Whoever's phone is on needs to be turned off.
He's posted a bond, so there's significant money at risk. And while I understand your concern, that same concern also applies here while he's out on bond in the state of Michigan. And he's simply, I mean, his employment is a very important part of his life, and as anyone's is. And I mean, that travel is necessary for his work. So if pretrial services can overlook it, or if the court feels more comfortable there, that way, I ask you to consider that as well.
So counsel, the concern that this court has is that, or not the issue that this court has is that whenever this court sends a request for pretrial services investigation or report, we don't get anything back. I don't know if they're ever interviewed or not. So I don't know how that would attach at this stage. I don't know if they're specific to Third Circuit Court, or they just pick and choose which courts they're going to supervise or interview defendants with. I don't know how that works. So when is your client expected to travel for work?
So that's a tough question, Your Honor, because the way it works is this: on Fridays at his company, Plug Power, they meet with regard to when these individuals need to travel out of state and what state they're going to. And they then make the arrangements to do that the following week. A week might be Mr. Miller having to go to St. Louis, Missouri for 2 days, and then perhaps travel to North Dakota and then back to Michigan. So there is no set time. It's just a part of his employment.
Well, Mr. Miller is going to have to communicate with his supervisors as to how he can be available via Zoom or otherwise, because this court's not permitting him to travel out of state at this time.
Very well, thank you.
Thank you. Bond and conditions are continued.
Thank you.
Have a good day. We are on the record in the matter of the state of Michigan versus Dominic Keithley, 251460. Does Mr. Kaplan know he needs to be zoomed in?
I just told him.
Oh, okay. I don't know if he was. Okay. All right.
Good morning, Judge DiSanto, Leo Ryan, on behalf of Mr. Keevy.
Good morning. Hold on, counsel. I show Ms. Bates as the attorney of record. Have you substituted in?
I spoke to her. We ended up in on Zoom in Southgate. Miss Bates, I think. I don't. The woman said she was gonna represent him, and I said I was paid by him. So
If you're a retained counsel, there needs to be something in the file. There needs to be a substitution of attorney. I don't have that.
okay.
So once we have that, we'll recall the case.
Fill out.
There should be one you can get at the window or otherwise. Here, that's this one.
Do you have her phone number so I could call her to get her?
Counsel, it's all on this, it's all on the website, State Bar of Michigan website. You can get her information and otherwise, but you should know that there's a procedure whereby attorneys can appear in a case, and there has to be a document, whether it's by appearance, if there's not a prior attorney, or a substitution of attorney if there's a prior
Well, I
attorney.
don't know if she was his
So-
attorney or not. She was showing up there. She.
Counsel, I'm not done speaking.
Okay.
If you looked at the file, it would show Ms. Bates's name on the file as the attorney that was appointed to represent him.
Okay.
If you were retained after that, then you need to file a substitution of attorney.
Okay.
Thank you. All right, let's go on the record in the matter of the state of Michigan versus Todd Steiger, 251646.
Good morning, Brian Mash, EP 85797.
Okay, thank you. And Mr., for Mr. Steiger.
Good morning, Your Honor. Michael Piechnik here on behalf of Mr. Steiger.
Thank you. And Mr. Steiger, your name for the record, please.
Todd Steiger, Your Honor.
All right, today's date scheduled for the probable cause conference. Counsel?
We've asked that we be given a date for our an exam. I think the date that we had discussed with the prosecutor, the next available date was January 8th, given the 1st is a holiday.
Okay, and if you can go over waiver, I think that it's already been established. If you can go over waiver of time with your client, please, counsel.
Mr. Steiger, you understand that the statute requires that the prosecutor in this court hold your preliminary exam within 21 days?
Yes.
And you understand that you and you alone have the ability to waive that if you so choose?
Yes.
And you understand that by waiving it, you're not giving up any rights, you're not admitting to any guilt or anything, you're simply just allowing the state and the court to hold that exam past the 21 days?
Yes.
And you're willing to do that in this case?
Yes, sir.
Thank you, Mr. Steiger.
All right, the court will note that time has been waived on the record. And the court will schedule this matter for exam on January 8th at 1:30 p.m. Witness exhibit list by January 5th. And then bond and conditions will continue. Sir, if you're to test right now, what's in your system?
There should be residual THC, but I haven't smoked since I got arrested, miss.
Okay. All right, very good. We'll see you back on January 8th. Thank you. Have a good day.
Okay, thank you, Your Honor.
Thank you. And then
Your Honor,
we're on the record in the matter of the state of Michigan versus Frederick Moore Jr., 251615.
Frederick Moore.
All right, thank you, Mr. Moore. And counsel for Mr. Moore?
Good morning, Your Honor. Michael Piechnik here on behalf of Mr. Moore. I apologize. I thought Mr. Kaplan was going to put his appearance on first.
No, that's okay.
I'm sorry, Your Honor. Stephen Kaplan, Your Honor, on behalf of the people.
Okay, thank you. All right, Mr. Moore, you're in a vehicle, but you're not driving. Is that correct?
I'm parked. I'm not
Okay.
driving.
Okay, very good. And so today's the date scheduled for the probable cause, the adjourned probable cause conference in council.
We're requesting this be set for an exam as well,
I'm presuming January 8th.
if it's available. And just a quick question, Mr. Steiger, did you say 1 or 1:30?
1:30.
1:30, thank you.
So we'll set this for exam on January 8th at 2 p.m. Council, I believe, if you can go over the time waiver with your client as well, please.
Yes, Your Honor. Mr. Moore, you understand that statute requires that the prosecutor in this court hold your preliminary exam within 21 days of your arraignment?
Yes.
And you understand that you and you alone have the ability to waive that right and allow the court and the prosecutor to hold this outside of that 21 days?
Yes.
And it is your choice to allow, to basically waive that right and allow this exam to be conducted slightly outside of the 21 days in this instant case?
Yes.
Thank you.
All right, the court will note that time has been waived on the record. Witness exhibit lists are due January 5th. Bond and conditions are continued.
Thank you, Your Honor.
Thank you. Have a good day.
You as well.
Thank you. All right, let's go on the record in the matter of the state of Michigan versus Nicole Unsworth, 251086. And counsel, your appearance for the record, please.
Your Honor, Stephen Kaplan, on behalf of the people.
Najad Mihan appearing on behalf of Ms. Nicole Unsworth, P59371.
Okay, Ms. Unsworth, your name for the record, please.
Nicole Unsworth.
Okay, and you just turn on your camera.
Okay, hang on. I'm sorry. There we
Your
go.
Honor, if I may.
Okay,
Your Honor, we have a waiver of the exam to circuit court. People have no objections.
okay. And so, you understand that you do have the right to have a preliminary examination, or it must be shown that a crime was committed and probable cause exists to charge you with that crime. You understand that?
Yes.
And you also understand by waiving your right to your preliminary exam, you will be bound over to circuit court for further proceedings on the charges in the complaint and warrant. Do you understand that?
Yes.
And have you received notice of those charges in the complaint and warrant?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No.
Counsel, do you have an objection for the court indicating via Zoom on both your signature line and your client's signature line?
No.
All right, the court will note examination having been waived, defendant is bound over to circuit court for further proceedings. You are to appear in circuit court on January 6th at 9 o'clock in the morning
Okay.
on the charges in the complaint and warrant.
Thank you.
Okay. Thank you.
Conditions will continue. Thank you. Have a good day.
Thank you.
Thanks.
Let's go off the record for a moment.
You're good.
Okay, friends, she's full of cheer this morning. Little grumpy. Sometimes we get that from Judge Mom. Let's switch it up though. Let's go from Judge Mom to Judge Dad. See what's going on there.
It looks like Judge Mullins, I believe I was absent that day, as I recall it. I don't know if you remember, Lisa, but I was absent, and Judge Mullen, my place, I think,
Yeah, you're correct.
set a
Judge.
5,000, 10% bond and ordered him not to have any contact with Adam Grote, not to enter or go near 3750 Brookshire and Trenton, no contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs, no firearms, no dangerous weapons, and defendant was required to obtain a tether within 24 hours of release from custody. So, hang on one second. See,
Yeah.
I'm gonna talk to you about bond sheet marijuana. Well, I've been meaning to talk to you about that for 2 weeks. Okay, so then I got a signing on record on the, he was in Chattanooga, failed to acquire the GPS. Court found by preponderance of the evidence that the defendant violated his bond condition by failing to acquire a GPS. I revoked the release, forfeited the bond, and ordered $50,000 cash or surety. So, what are we gonna do on this one, Mr. Westmoreland? I mean, I could take, you can just argue bond, or if you want to have a bond hearing as to whether or not he failed to acquire his GPS tether as ordered by Judge Mullins, that's fine too. What is your preference here?
Your Honor, I would just ask that this matter be reset, and I will argue bond on behalf of Mr. Flesher.
Sure, go ahead.
Your Honor, I would like you to know that Mr. Flesher is currently homeless, and he is currently unemployed, so he has no means of paying for any sort of tether. He's not currently on probation or parole. I don't believe he has any prior criminal history. At least he indicated to me he did not. He has no other pending matters out of any other court. And after speaking with Mr. Flesher at length this morning, he did assure me he would be appearing at all future court dates, and he does understand the importance of doing so. I believe last time he felt that he was threatened and he could not appear. But moving forward,
Wait a minute, say that again.
Mr. Flesher indicated to me that he felt that he was in grave danger and he could not appear.
Danger by who? From who?
Your Honor, I'm not exactly sure at this time, but Mr. Flesher did assure me he will appear and he understands the importance of doing so.
Did he make any police reports?
Not to my knowledge.
He's, I don't know if we ever, if Judge Mullins ever signed the complaints. Wonder if we can send that, can you send that over to her? Oh, wait a minute, she signed the warrant, that's, and, oh, she did sign the complaint. Why did you leave without getting a GPS tether, sir?
I feel that my life is in danger, and that's what set this whole thing in motion.
Your life
The
is in
mail,
danger.
I have no interest in defrauding, Grow It, Adam.
I want you to talk
anybody
about
else.
the, hang on. I
What,
don't
sir?
want you, hang on. I want you to talk about the case. You should not be talking about the case.
Okay.
I don't know why you're telling me your life was in danger. Did you tell Judge Mullins your life was in danger when she was setting the bond?
Yes, I've told everybody.
He tell you this, detective?
He did not, Judge. Me and Mr. Fletcher has not had any real conversations to that effect.
You told Judge Mullins at the time of the arraignment that you felt your life was in danger? I don't want to put words in your mouth.
A tether tracks to exactly where I am.
Say that again?
The tether would track to exactly where I am.
We know
I
that.
am moving, I was moving around to try to avoid. I have to give you the whole story, or you don't get the whole picture. Yes, my life is in danger, absolutely 100%, and I have documentation that proves it inside and out. That's why I'm more than happy to come to trial. I'm more than happy to speak to a judge and a real lawyer and everything else. I have no problem with that.
I'm a judge and he's a real lawyer and he's a real detective. So
Okay.
Listen, Mr. Fleeser. You were ordered to get a GPS tether. I know not what you're talking about, sir. I do not know what you're talking about. Have you ever treated for mental illness, sir?
No, sir.
You work?
I haven't worked in a long time, sir.
How long?
I don't have a problem working. I'm not a bum. I have skills. I'm more than
Nobody said you
capable.
were
My
a
phone
bum. How
calls are
long since you've worked?
Since. So you mean since I've been paid for work? Probably about April 2008, maybe.
Where do you live now?
I'm denied employment. My phone calls are intercepted.
Where do you live now?
Visits to law offices are intercepted.
Listen,
Just
my
telling you,
question.
I want to be honest with you.
Well, I want you to be honest with me too. Where do you live now?
I go from hotel to hotel to hotel to outmaneuver whatever the heck it is that's coming after me. I broke a code and I gave the information to the feds in April of 2008. And I've expanded on it quite a bit. The code is basically how they get rid of people they don't care for.
The federal government you're talking about?
Correct.
Oh, boy.
It's none of it's legal by any means, but it's very damning to say the least. So I kind of keep that to myself, but it doesn't allow me to survive. Like I said, I'm not choosing to have my calls intercepted. I'm not choosing to have my automobile sabotaged, my family's home sabotaged. The list goes on, and that's why I know you don't want to go into detail. But I have to be honest with you. Yes, my life is in danger. That is the whole reason why I'm here. Why I took the mail that I took.
All right, you should not be saying that. You should not be saying that. You should not be saying that, sir. You just should not be saying that. I'm trying to caution you, not listen to me, please listen.
Go ahead.
You shouldn't be making admissions. You should not be making statements that are against your interest. I'm concerned here. I don't know what to tell you. I'm gonna set $2,000 cash or surety. $2,000 cash or surety that you're going to have to post. And this time, I'm going to change the bond conditions ever so slightly. You're not to have any contact with Adam Grote. You're not to have any contact with prosecution witnesses. You're not to enter or go near 3750 Brookshire in the city of Trenton. You're not to possess firearms. You're not to possess dangerous weapons. You're not to purchase, possess, or consume alcohol or illegal drugs. You're not to be released until fitted with a GPS tether. You're not to be released until fitted with a GPS tether. So even if you post the bond, you're not going to be released until they can fit you with a GPS tether. Also, I'm going to order you to attend a psychological evaluation and treatment. You can call the probation department. So if they recommend probation's going to give you some names as to where you can go. You're to attend a psychological evaluation and treatment if recommended. So those are the bond conditions. I'm adding a couple that Judge Mullins did not have. And you have never heard anything about this at all, Sergeant?
I have not, Judge. I know there was some conversation about his monies being funneled out of his bank account, but we didn't get into a conversation involving people coming after him.
All right, so Mr. Fleezer, I'm sorry. I'm gonna give you a new date. It's gonna be, what, January the 6th, is it? Lisa?
January 6th at 10 o'clock.
January the 6th of 2026 at 10 a.m. I hope you didn't pre-try that with those guys. I told them we needed an Arabic interpreter.
His son spoke for him.
Yeah, I can't do that. It's a criminal case. I just can't do
I understand.
I just can't do it. I tried to tell them that. I mean, it's a criminal case. I'm supposed to get an interpreter, so I can't, I'm sorry, I just can't do it. That's the way it is, Mr. Fleezer. I'm sorry. So I want you to get a psychological evaluation and treatment. You can post $2,000 and you're not going to be released until fitted with a GPS tether. Okay? Do you understand, sir?
Yes, but I don't have $2,000.
I'm sorry. You should have shown up. You should have shown up. You didn't get your tether and you left the state.
I was told that the actual judge wouldn't be there.
What's that?
I was told the actual judge wouldn't be there, that somebody would be sitting in who doesn't actually normally be there. Plus, the lady that I spoke to, that was the judge, had the same name as you, sir.
No, she did not have the same name as me. It was Judge Mullins.
It did on the screen when I talked to her, because I was wondering why it was McNally, because that was the paperwork posted on her house.
Okay, listen. You were in front of Judge Mullins. You were in front of Judge Mullins. She told you to get a GPS tether. You didn't. I'm not going to argue with you. You're going to have to post $2,000 and they'll give you a GPS tether. If you post the bond and you get the tether and you are released, I want you to get a psychological evaluation and treatment, okay? They don't need to come in here. I already told them to go down the home.
I know, Judge, he can speak English. Young.
No, Mr. Muhammad, come on. He told
Judge, we
me
all
he
set?
could just, yes.
Thank you,
He
Judge.
told
thank
me
you.
he told me he could speak a little bit, and then he wanted to have his son interpret for him, and I can't do that on a criminal case. Call the state court administrator's office. They're gonna tell you that. I mean, I can bend it on a civil infraction just a little bit, but
I understand.
it's not my call. I just do what everybody tells me to do here.
I understand. It's just we discussed this whole case in England. So that's why
Why did he tell me he just could do a little bit? Why was he, when I was conferring with him, asking his son? I can't do it. I'm sorry. Marion Carriel Banks.
What can I do with the file?
Have them go down the hall and they'll get their notice and they're gonna have to come back. I'm sorry. Graziani is not in here on that one. People against Robinson, Brandy Monet Robinson, 25M 626 128 A and B. Where is Brandy Robinson? There you are. Ma'am, you have to start your video and state your name, please.
Brandy Robinson.
You have to, there you go. Good morning to you, ma'am. How are you?
I'm
Do
good.
I-
How are you?
Good, thanks. I have a feeling it's gonna be a good day for you. Trooper Brown's not here, right, Lisa?
Not on Zoom.
Ma'am, congratulations. I hope you got insurance. You gotta slow down, but he didn't show up. I gave him 15 minutes. He's not here. Cases are dismissed. Good luck. Merry Christmas to you. Don't drive
Thank
without
you.
insurance. That's a bad thing, okay?
Okay, thank you.
Merry Christmas. Good luck. Thanks.
Bye.
Bye now. People against John Perry. John Patrick Perry, 25I 715 127. Let's see. Good morning.
You just sit right.
Who is Mr. Perry's lawyer, Lisa?
It's an arraignment pretrial.
Oh, you're Mr. Perry?
Yeah.
How you doing?
I'm not doing.
Good. Have a seat there. This is John Patrick Perry, 25I 715 127. I have two counts. Operating while intoxicated and open intoxicants. Your name, sir?
Joe,
What is your name?
John Perry,
Good morning.
John Perry. Hey, thank you.
You're here for two charges, misdemeanors. You have the right to a lawyer.
Yeah, because
Hang on,
I don't need a lawyer.
hang on, slow down. Just stay, hang on. Ma'am, you can stay right there. You can sit behind him if you want, but you should get a lawyer, Mr. Perry. I'm gonna give you a lawyer, okay?
We have a.
Who is this next to you? Behind you?
My wife.
Oh. Oh,
I don't drive anymore.
well, I get it, but do you want a lawyer? What is your name, ma'am? Tell me your name nice and loud.
Brenda Woodruff.
And you are married to Mr. Perry? Are you married to Mr. Perry?
No.
No, not legal.
That's legal.
All right. Okay, but you stay together.
Yes.
All right. You said something about a lawyer. Are you gonna hire a lawyer?
We have a lawyer, Sean Perry,
She's prosecuting attorney. and-
his daughter.
My daughter.
Okay, let's slow down. Let's slow down. Just slow down. Is Sean Perry here?
No. Yes.
Sean? She's not here. Is it a she or a he?
He.
And she's the prosecutor?
Attorney.
For who?
Muskegon.
Muskegon County.
And she's going to represent you?
Yeah.
But she couldn't come today?
Filed it guilty and that was it.
No, well, you're not, you don't want to, listen, just relax. Let me just walk you through this here, okay?
Okay.
What are you, 87 or 8?
Sorry?
Are you 87 or 8?
Oh, yeah.
Good for you.
It was 90. He got my pilot license. And one of those.
I'm a little concerned about this.
Okay.
I'll either give you a lawyer right now for arraignment, or I am going to arraign you. And then we'll set it for a pretrial.
Okay, whatever.
Do you want me to give you an arraignment is where I explain the charges? Listen to me very carefully, sir. I want you to look at me and just listen. An arraignment is where I explain the charges, the possible penalties, and your rights. And then I set a bond. Do you understand that?
Wait.
I'm gonna give you a lawyer. We're gonna give you a lawyer for arraignment today, okay? That's what I'm gonna do. I'm gonna give you a lawyer for arraignment. It'll take a few minutes. Mr. Graziani, you're our guy, right?
Yes.
So you can just, this is a township case. Is that still gonna fall under your purview or not? Let me see.
I believe so, Judge.
No, it's a state case. So I'll give you that.
Okay.
And then you can just, we'll get them arraigned. I'll set bond and we'll go from there, okay? Just stay right there. You're gonna talk to this gentleman here in a couple minutes, all right?
Yeah, I'm gonna go.
Are we ready on Marion Banks?
Start, Judge.
People against Marion Carol Banks.
Morning, Your Honor, Nor Ali.
703. Good morning, Ms. Alway. Your name
Sorry
again?
about that. Good morning, Nor Ali on behalf of the people, PA 6528.
Ms. Vojanov, can you unmute and tell me your name, ma'am?
My name's Jenna Vojanov.
Okay, just keep your voice up nice and loud for me, Mr. Graziani.
John Graziani, P number 43387. Judge,
Sir, your name?
Mario, thanks.
All right, what are we gonna do on this?
Judge, I've spoken to, Madam Prosecutor and, in discussing the matter and looking at the logistics, it appears that we're better off than turning it over to the, civil system, the family court, Wayne County Judge.
Now, what is the name of the victim here again, please?
We have Jenna Vojanov.
I know that, but I was more concerned about the kids.
There's one child that's 3 months old. Her name is Lila. And so after speaking to the complaining witness on this matter, I would ask the court, keep that no contact order in place. And as for the language, it would be no contact except to effectuate any child custody order.
Okay, so defendant could not have contact with Lila. Is it Leila?
Yeah,
How do you spell the name is all I'm asking, ma'am.
it's Lila.
Okay, and Lila, is the last name Vojanov or Banks?
Yeah, it's my last name.
So defendant cannot have any contact with Lila Vojanov except as permitted, allowed by the Wayne County Circuit Court. So I'm not going to get into that. And that's going to be an addition. I don't know if I didn't write it down.
If I may interject, what's happening is, Mr. Banks has his sister's foster parent who would be able, and she's licensed and would effectuate any potential visitation because of what's going on in your court.
Yes, but after speaking to defense counsel, we agreed that it would be it would be on the parties to excuse me.
The family court.
To go
I
to
get
family
it.
court. And
Who's your probation officer, sir? What's Emily's number, Sadie, again? Do you know? Wait a minute, I might have it right here. I'll be right with the rest of you here if you just be patient with me, okay?
Hello.
Can you come in here on Marion Banks, please?
File?
Maybe. It's not a big deal. Either way, come in without the file. Thanks. So I don't know if I didn't write it down, but the intent that I was concerned about here wasn't so much about him not having contact with Daniel and Colleen and Jenna. I had that concern too, but it was more about the reason I talked to you guys at the time and said, hey, we'll try to get the victim here. And I'm talking about the mother of the child to see if something can be worked out with visitation. And the reason I did that is I recognize Christmas is coming up. So I'm going to have her prepare an amended order that says no contact with Lila Vojinoff, except as permitted by the Wayne County Circuit Court.
That sounds great, Judge.
Okay?
That's correct, Your Honor. Thank you.
Okay, so that's what I'm gonna do. Just your name.
Just hold on.
I didn't know whose case this was. He said Emily's. I'm sorry.
That's okay.
I focused, remember, I think you were in here that I said I wanted to see if I could effectuate visitation for him. It looks like everybody's agreeing to, but I didn't write it down on the order. So I want you to do an amended order that says she's not to have any contact with Lila Vojinoff except as permitted by the Wayne County Circuit Court with regard to the custody and visitation issues they have going on there. I'm sorry. I wish you well. You gotta, I won't say another word. Good luck. Thank you.
Thank you, Your
all.
Honor.
Thanks.
Again, just before we leave, I just wanted to mention that Mr. Banks, particularly because of these underlying issues, doesn't want contact, no disrespect, with folks who are involved in the situation.
You're not gonna contact him. I can't order him not to have contact, but you're not gonna contact him either, right, ma'am?
Again, Judge, what we're trying to do is just effectuate visitation down the road.
I got it. All right.
Very good.
Thank
Have a
you, Your
good day,
Honor.
you guys. Thank you.
Thank you very much.
Kayla Anders. Kayla Nicole Anders, 25M616-565, A, B, and C. Boy, you should have been a lawyer, Ms. Anders. You did a good job for yourself here. Your name?
Kayla Andrews.
So you're gonna plead to speeding, right? And that's on count 2. They're gonna dismiss the careless. And then you presented proof that you had a valid license and no insurance. And they're gonna dismiss those. So you're walking out with a misdemeanor dismissed, no proof of insurance dismissed, and instead of a careless, you're going to plead to 5 over, which is just it's a 1 point. It's not limited access. Do you understand that?
Yes.
Is that what you agreed to?
Yes.
To the charge 1 to 5 over, responsible or not responsible? Please accepted, careless dismissed, 155 is your fines. I'm also dismissing on motion of the prosecutor the no ops as well as the no proof of insurance. You can pay that today?
Not today.
How much do you have today?
I'll pay today.
Are you sure? If you can't, you can. I don't mind giving you time. I'm not,
My dad said go off the pay.
your dad's a good guy, huh?
He is, very good guy.
All right, well, good luck.
Thank you.
Merry Christmas to you. You can go down the hall and take care of that. Thank you. Do I have John Garza? Where's Mr. Garza? Where's the lawyer, Mr. Bazzi at? Is he here? I don't have any other files, guys. I got.
Judge,
ahead.
it just came down in your stack of done files. I just noticed it.
Mr. Bazzi, are you ready on this? People against John Edward Gazda, 25M628-626. A. And it looks like I should have a B file, but I have no idea where it went. Do you have a B file on it?
The B file's down here. It came down in your done cases. The cases you just finished.
That's a misdemeanor too. Mr. Bazzi, your name? I don't know how that happened. I'll get the B. John, would you go get the B file and we'll take care of that, please? I don't know.
Judge,
Right.
especially signed counsel and I are ready on Matthew Levens.
I don't. Okay, I just got that. Matthew James Levens, 25W702931. Okay, appearances. Your appearance. Mr. Cripps.
I'm ready. I'm here. David Cripps, P34972, appearing on behalf of Matthew Levens, Your Honor.
Ms.
And good
Johnson?
morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
So what happened here? They're not going to do the evaluation until January 14th, right?
Correct, Your Honor.
Who's the Woodhaven detective on this? Can you tell me? Is Lieutenant Toller here? Ms. Johnson, I've got this note here, needs printed. So I don't know if he was printed or not. Where's your client at? Mr. Levens, your name?
Yes. Matthew.
You got to tell me your full name, sir.
Matthew James Levens.
All right, so first of all, let's take care of this. I'm gonna go ahead and order that you go over to the Woodhaven Police Department by noon today, December 23rd, to get printed. So you have to go over there. That is a condition of your bond. That's number one, okay? Do you understand me? You have to go over there and get printed and photographed, all right? You understand that?
I did, when I was there.
You have to do it again. The judge is ordering you to.
Yeah, unless, I don't have this, I can't find this CCH here, but it says needs printed, Lisa, unless you just put that on there before and it wasn't taken off. Maybe you can check on that. Let me just
Right now,
double check.
Judge.
And then I'm gonna go ahead and adjourn this, you guys,
Thank you.
to another date. It looks like they're not gonna do the evaluation until January the 14th. So you have to make sure you show up on that day, sir, for your evaluation. And then I'm thinking we adjourn this, the competency review date, competency hearing until, what do you think, like early February, Lisa?
Mi-
How long's it taking, guys? You know better than me.
At
About
least,
4 weeks,
at
5
least,
weeks?
at least 4 weeks to 6 weeks on the
All
competency.
right, let's go like the 3rd week of February, 4th week of February, Lisa.
February 17th at 1 o'clock.
Maybe another one. Maybe we go further than that because
The 24th?
Yeah, let's try the 24th. That,
Okay. February 24th at 10 o'clock.
all right. So, Mr. Levens, make sure you show up for your evaluation. Make sure you write down you're going to be here February 24th at 10 o'clock. That's going to be in front of Judge Hessen. And then make sure you go over to Woodhaven. I don't know where.
I'm checking right now.
Yeah,
Was-
just give me one
Was the
second.
offense date January 12th on that?
No, it was August 1 of 25, unless, you know, that works sometimes.
Let me look it up real quick.
Judge, on the 24th, would that be on your docket?
No, you're going to be in front of Judge Hessen then. We're switching over state dockets.
Judge, I remember now that I see the criminal history. There is a print segment for Woodhaven. It has a different incident date and the reference number is off by 2 numbers. So I'm
maybe I
not sure
better
if
send
they
him
made a
over there.
mistake.
I think you better go over there and get printed again, sir. I'm sorry. And then, Lisa, I'll just ask you to figure that out when you get a chance.
I'll follow up. Yeah.
Okay? And Mr. Levens, if you have a pen there, do you have a pen?
Yes, Your Honor.
Can I just have him call you directly in about an hour, Lisa?
Sure.
734-671 extension 230.
Are you?
Okay? That should be it. You're all set. Call Lisa at that. Merry Christmas, Ms. Johnson and Mr. Cripps. Have a great day and happy holidays, and Merry Christmas to you, Mr. Levens. Good luck. Thank you.
Will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
January 20th at 9 a.m. before Judge Bello.
January 20th, 2026, 9 a.m. Scheduled before Judge Valvo or her successor. Found will continue. Thank you.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Christopher Brewer.
Water Assistant Prosecuting Attorney for the People.
Assistant Public Defender Ben Dunaway for Mr. Brewer, who is joining me at the podium now. Would you state your name for the record, Mr. Brewer? Christopher Brewer.
Thank you.
And Your Honor, we would like to set this matter for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses with 6. People have their witnesses available January 6th.
I believe so, Your Honor.
Preliminary examination in person, January 6, 2026.
Don't leave.
9 a.m. before Judge Barr. Found will continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Jessica Williams.
Water Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Justin Zade appearing on behalf of Ms. Williams. President consents to appear via Zoom. Ms. Williams, can you state your name?
Jessica Williams.
Thank you. All right, what are we doing?
Your Honor, this is the date and time set for an adjourned PCC. Last time we were here, early December, we submitted a deviation request. We still haven't received a response to that, so we're just awaiting word from the prosecutor's office.
Is that correct? The prosecutor's office is in receipt of it? What are we doing?
Checking right now. I do not see that in our file, so I wasn't aware of that. I will get with Mr. Zaid and make sure that he gets put in there.
For the record, it was originally sent to Mr. Cook. He indicated that he would be off the file and would forward it on to the assigned prosecutor.
All righty then. Here's what I'll do. You guys get that straightened out. I'll adjourn this to January 15, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Understood. Thank you.
No, that one. Where's Mr. What'd you do with Mr. Zaid? I'll just call it. Of course, recalls the case, People versus Lucretia Pender.
Justin Zade on behalf of Ms. Pender. Ms. Pender, can you state your name?
Lucretia Pender.
Thank you. What are we doing?
Your Honor, in this case, the court will see it is a welfare case, so there is some additional contact I need to have with the office that investigates these cases to see about what sorts of things they'd like to see as a result. You know, we're familiar, sometimes they want to see a forfeit benefits, things like that. So I need a little bit more time to work on that.
That objection, I'll adjourn the probable cause January 15th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls the case, People versus Devon Brown.
Ray Pappen appearing on behalf of the Attorney General.
And good morning, Your Honor. Assistant Public Defender Alexis Serps with and on behalf of Mr. Brown, who's approaching the podium.
Are both of these Attorney General is?
No, Your Honor.
No, one is a state case. So. All right. Your name, sir?
Devon Brown.
Okay. So in the Attorney General matter, he's waiving.
Your Honor.
Correct. All right, sir, you're waiving your right to a preliminary examination in the case involving your failure to pay child support?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Acknowledge receipt of the information, waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, or will enter a not guilty plea to all counts. Pretrial will be set for
January 7th at 1:30 before Judge Conlon.
January 7th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue in that matter.
Your Honor, may I just respond briefly in that matter?
In which one?
The child support case, Your Honor.
You want to address bond?
Yes, Your Honor.
Go
Mr.
ahead,
Brown.
take a shot.
Mr. Brown would like me to ask the court either a reduction or a personal bond, Your Honor. When this matter took place, he had just recently lost his job. In Houston, he came back to Michigan to support his little brother who's special needs. He helped take care of his brother. He has been fighting for his daughter for the last 10 months. Before being brought into custody, he was working 4 different jobs. He was shipping cars, doing DoorDash, working down at Eastern Market when there was home line games, and working as a sous chef at Blue Cross Blue Shield, Your Honor. He's been in custody for 8 days as of today.
But the bond was set at 25% of what the outstanding charge was, correct?
Correct, Your Honor.
Well, I don't think statutorily I can necessarily do anything with that, and I'm not inclined to. But you can go ahead with finish your argument if you want.
Your Honor, that was the last point that I was going to make, is that he just wishes to get back to work so he can start paying on those arrearages and move this case along.
Okay, I understand that. I don't need a response from the people. Motion for bond reduction is denied. Bond will continue.
Understood, Your Honor.
Thank you.
And then on the other matter, his state case,
Yes.
We were just requesting an adjournment on that one, Your Honor. We got discovery late yesterday and we need a chance to review that with him.
Is there a green sheet on that one?
I
Oh, you
believe I
might have
already
given
submitted
it to
Your
me.
Honor.
I think you did. It's just other file. All right. That objection, probable cause. January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Case People versus Harold Couch.
And good morning, Your Honor. Joseph Hall appearing forward on behalf of Mr. Couch, who now stands to my right. Mr. Couch, if you could state your name for the record, please.
Harold C. Couch Jr.
Your Honor, we're here again. We are awaiting the DNA test results in this. I've spoken with Mr. Kennedy, not recently. I believe he's out of state. That's why his case is being covered. So I don't have an immediate update on the whereabouts of these results. Been requesting them for some time. And I have no doubt that the forensic center, that the forensic science division will get there. I can't say when.
And I don't have an update on the time frame. Last update I got from Mr. Kennedy was that we just don't have the report back yet. I didn't get a time frame.
During this matter, January 22nd, 2026, 9 a.m.
And thank you so much, Your Honor.
Thank you.
Your Honor, I do have an 8:30 in 34th District that day.
I'm sorry.
You're more
I'm
important.
sorry. I'm sorry to hear that.
Um,
So what do you want me to do? Call them and tell them cancel their docket? Or are
Absolutely.
you asking me to do something that I'm not gonna do?
That's what I'm doing.
Okay.
Doing the second one. And if I could
Not
get.
doing it. Talk, right? You're not doing it.
That's what it is. It's a,
Like Hall?
attrition. I think I could do the conflict waiver in no less than 300 words, by the way. I know 20 or 30 was
Yeah.
talked about.
Yeah,
I
that
could,
would,
I could.
that
sit
would
at
take
least that long,
forever.
Judge.
The fact that you said that, I realize I'm very blessed by the people doing it. Go ahead. So what do you want me to?
So if I could just come in a bit later that day, I'm sure I could be here by 10:30.
We'll wait with bells.
Thank you so much, Your Honor. I appreciate you.
Court does call the case, People versus Kadera Akiji. 3 cases.
You want to do it down here? Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji on the case ending in 1678.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Akiji on the other 2 cases, the ones ending in 5790 and 5801. Mr. Akiji, can you state your name for the court, please?
I think he was saying it.
Thank you, sir.
What are we doing?
Your Honor, we're here. We've requested a competency evaluation and also criminal responsibility evaluation. I also sent over some supplemental materials there.
And I do have the same request for both of my files, Your Honor.
Okay, I have did you submit? They're in there. Okay, they're just not marked. Okay. So what I will do is I will sign that for the forensic evaluations. Set competency hearing in this matter for March 26, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Bye, Mr. Ikeji.
Court calls case of the People versus William Riddle.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Riddle, who approaches the podium.
Your name, sir?
William Michael Riddle.
All right, what are we doing?
We had set this day to make sure that I had all the discovery. I've spoken with Ms. Zenda at great length. I have all the discovery, and I believe we have an exam set for next week, Your Honor. We're good to go.
And Your Honor, this was the case where we originally thought we had discovered before. We were up last week and the court indicated they would set it on the 30th.
Right, I had not said it yet, but I would set it on the 30th. Okay.
My apologies, Your Honor. I thought it was already set. I had such faith in Ms. Zenda's office.
Preliminary examination in person will be set for December 30th, 2025, 12 noon. And that is before me.
Thank you, Your Honor.
Thank you. Calls case People versus Amber. Almany.
Assistant Prosecuting Attorney for the People.
And Assistant Public Defender Natalie Pate stepping in for Mr. Gaddy on behalf of Ms. Alamy, who stands to my right. Please state your name.
Amber Almany, Your Honor.
Thank you.
Thank you, Your Honor. I do have a green sheet prepared by Mr. Gaddy, Your Honor. We are requesting an adjournment for mitigation purposes.
Without objection, probable cause conference will be adjourned to January 15th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, ma'am. Court calls case of the People versus Moses Cunningham Page.
Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Assistant Public Defender Alexis Earps with and on behalf of Mr. Cunningham Page.
Your name, sir?
Moses Cunningham Page.
Thank you.
Your Honor, he is executing a exam waiver. Right. And Your Honor, with that,
Sir. Go ahead.
I did submit an order for release to inpatient treatment that was going to be a part of the agreement between defense and the prosecution for an order that may be available to him in circuit court.
People had no objection to that order.
No, Your Honor.
But he does need, yeah, you're gonna need a tether for prior to release. All right. Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
All right. People also waive their right?
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
We acknowledge receipt of the complaint, waive the formal reading and stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
January 6th at 1:30 before Judge Company.
January 6, 2026, 1:30 before Judge Company. Bond will continue.
Thank you, Your Honor.
All right, thank you.
All right, let's change it up again. Let's go back to DeKalb County and Mike Jacobs. It looks like he's starting to work with people in Orange now.
As well, that doesn't show as having a case number on Odyssey. I'm just going to request a bond, a reduced bond for all three of them together. But for some context, Judge, she has been held for 7 days. These are three separate shoplifting cases. She has a $1,000 bond on each of them. My request to Your Honor would be that Your Honor reduces her bond to $1,000 inclusive of all three cases. With regard to Ms. Collins' biographical information, she's 63 years old. She lives with her niece in Fulton County. She's been here her whole life. All of her ties are here. She has a son who she cares for who recently sustained injuries in a bad accident. She is currently unemployed and looking for a job. She has work history doing hair and has a bunch of practice hours in cosmetology. She also is diabetic and needs daily medication. I understand, this is three separate shoplifting cases. I would request that Your Honor reduce her bond to $1,000 for all of them. $3,000 is just, she's not going to be able to post that. She's not, obviously there's no allegations of violence here, that she's a threat to anybody. So I would just request that Your Honor reduce her bond.
Mr. Weldon?
Yes, Your Honor. The state has a number of concerns with reduction here. In addition to, I guess, the now two other pending DeKalb County shoplifting charges, she also has another pending shoplifting charge in the Metro Atlanta area. And this defendant has at least 13 convictions on her record going all the way back to the early 80s. Consistently in each decade since the 80s, this defendant has picked up charges. And one of those, at least one of those being a felony. So given the three other pending shopliftings in Metro Atlanta, the defendant has shown a clear disregard for following the rules of the law of the state of Georgia, and the state would just request a bond citizen.
Well, I mean, we're still asking to keep $1,000 bond in place. So, I mean, I think that's fair under the circumstances. So I'm going to, I'll tell you what, I will convert 2 of the 3 cases to a UJR. And one of them whatever the most recent cases needs to have no change. Whatever the most recent cases needs to have no change. But the earlier 2 cases can be UJR. Don't violate the laws of any governmental unit or entity. Stay away from all incident locations. So all 3 of them need to be in each bond order. All 3 locations need to be in each UJR order. So the locations for all 3 cases. Stay away from those 3 locations. And I mean, unless are they like all Walmart cases or no? Like one store? Ms. King, you're muted.
Oh, sorry. Okay, I'm looking right now.
Looks like CVS.
All right, well, never mind then. So we're gonna do yeah, let's do yes, that one defendant is good to go at the juvenile detention center. That you're all set. And then but not the Sumter County defendant. And then yeah, all right. So all 3 incident locations in the 2 UJR orders. So UJR, don't violate the laws of any governmental unit or entity. Stay away from all 3 incident locations. Return to court on a future date that I will set, and we will leave one of those $1,000 bonds in place.
And I think it's the same CVS, Judge, by the way.
Oh,
so
well,
it should
fine.
just be
well,
one.
I'd stay away from the CVS.
Yeah. Yeah, gotcha.
Alicia Dixon, 2 cases.
So Judge, she's actually only being held on a case that's not on the calendar that the state has consented to a UJR on. So I will be preparing that order for Your Honor. And
okay, that's fine. Let's move on. Consent UJR,
okay.
Right, Mr.
Gotcha.
Weldon?
Yes, state consent.
All right. Thomas Gask.
For Mr. Gaskew, Judge, this will be a bond hearing. It's my understanding, I thought Your Honor would be in the courtroom, but Mr. Weldon informed me that there may be some individuals who are here in support of him. I believe family members. As far as biographical information, Judge, well, Mr. Gaskew has been held for 7 days on no bond. I believe he was denied bond at first appearance because he is currently on either probation or parole for a charge that he, I believe, paroled out, and Mr. Weldon will correct me if I'm wrong, paroled out in 2022.
You don't need to stand around. I'm not here. We're not going to be able to do that today. So just leave it on Mr. Weldon. I mean, family members don't necessarily have a right to address the court.
Understood, Judge. I just wanted to let you know.
Handle it today.
Okay.
So,
circling back, Judge, yes. So he was denied bond because he's currently on probation or parole. He is 33 years old. He has a stable address in Lithonia where he's lived with family for years. No objection to a no contact with the alleged victim. They don't live together. He is from Georgia. His family is in Georgia. Obviously, he has significant family support since they came all the way out in person for this court hearing. He has, I believe, a child on the way. He has a high school diploma as well as a certification for business administration. He has a stable job loading and unloading delivery trucks and stocking shelves for a brand distribution business. he will return to that. We're just requesting, Judge, I understand that he was initially denied bond, but it's my understanding that that was just because he is currently on probation or parole, and that will be handled. I'm sure he may be violated for that, but I would request that Your Honor set a low bond for him, like a $2,000 bond. And again, we would have no objection to a no contact with the alleged victim.
Mr. Weldon?
Yes, Your Honor. Judge Thompson, did deny bond on the 18th, last Thursday, under 1710-1 OCGA 1710-1. This 33-year-old defendant has quite the criminal history, including a very serious armed robbery conviction in 2013 in Cherokee County. The conviction was armed robbery, the hijacking of a vehicle, possession of a firearm, and the commission of a felony. In Cherokee County, the defendant received 20 to 12 on those charges. 20 to 12. The defendant was released in 2022, and so my understanding is he would still be on parole. So parole is eventually going to find out about this. But the fact that he goes and commits a violent crime against the mother of his child 3 years after being released from very serious charges in prison gives the state some very serious concern. And the facts of this case, would the state would prove at trial that the defendant attacked Miss Elena Diaz, the mother of his child. He slammed her to the floor and kicked her in the face. So given the seriousness of these charges and the extensive criminal history, including serious felonies, including armed robbery and hijacking, the state believes a no change in bond, or no bond whatsoever being appropriate in this case. And yes, Your Honor, the mother of the defendant is here in court for the court's consideration.
All right. Well, that's not going to happen today. So, under the circumstances, I'm not going to order a change in bond at this time. I will order a 2-week bring back.
So Judge, no bond at all?
I mean,
would you consider setting a high bond? I understand the state's position, but
that's fair. I will tell you, with this history and the allegations in the case, it's not even going to be one of the I'm not even willing to put it on par with one of the high bonds that I might issue on a bench warrant, which
understood, Your Honor,
happens on occasion. I don't know, almost rare occasion, but certainly on occasion. I will grant a $20,000 cash or surety bond. $20,000.
Understood, Judge. With a no contact.
No contact.
And no violation of any law of the state of Georgia, Your Honor.
Yes, right, absolutely. And I do know that we need to interact with the magistrate court about that. Not my court, but we do need to talk with them about that. But 20,000 per the discussion in open court last week. But yeah, $20,000 cash or surety. Don't violate the laws of any governmental unit or entity. Stay away. A bond is appropriate under the circumstances, but I do think it needs to be a high bond and higher than I ordinarily give in the courtroom. So it's going to be under any set of circumstances. So $20,000 cash or surety. Don't violate the laws of any governmental unit or entity. Return to court on a future date that I will set, and stay away from the alleged victim.
Understood, Judge.